Good afternoon and welcome to today's webinar, the European Convention on Human Rights at 75 plus, Toothless, Tiger, or Effective Enforcer. I am Elin Hofferberg and I am joined by Dr. Jenny Gesley, and we are both Senior Foreign Law Specialists here at the Law Lab. At the start of our webinar, we wanted to provide a roadmap for you as we discuss the role of the European Convention on Human Rights at 75 and beyond, starting with the history of the European Convention, including the Council of Europe, followed by an overview of the history of the European Court of Human Rights, followed by decisions of the European Court of Human Rights, which include its influence on the text and meaning of the Convention, the implementation and enforcement of the judgments, infringement proceedings against states who do not implement the decision, and with some select examples. We will end by discussing suggested changes on how the implementation process looks, and also an outlook before we take your questions. That said, you can already now submit any questions you have in the Q&A, and we will answer them after our presentation.
Great. Thank you, Elin. So let's get started. And before we start, I'm going to put a link to the statute of the Council of Europe in the chat. So if you want to, you can also follow along. So the Council of Europe is an international human rights organization which was founded in 1949. It currently consists of 46 member states, which include all European Union member states. But it's important to note that the Council of Europe itself is not an EU institution. Even though I have to admit the names, they all sound very similar: Council of Europe, Council of the European Union, European Council. But again, it's not a EU institution. Russia used to be a member of the Council of Europe, but it was expelled on March 16, 2022. And we will provide more details on the reasons for and the procedure for expelling a country later in this presentation. Okay, so who can be a member of the Council of Europe? Article 4 of the Council of Europe Statute provides the criteria for membership. It states, and I quote, "Any European state which is deemed to be able and willing to fulfill the provisions of Article 3 may be invited to become a member by the Committee of Ministers." So Article 3 provides that states must accept the principles of the rule of law and of the enjoyment by all persons within its jurisdictions of human rights and fundamental freedoms, and collaborate sincerely and effectively in the realization of the aim of the Council. So the aim of these rules, which are codified in Article 1 of the statute, is to achieve a greater unity between the Council of Europe members for the purpose of safeguarding and realizing the ideals and principles which are their common heritage and facilitating their economic and social progress. So let's talk briefly about the history of the European Convention on Human Rights. So the European Convention on Human Rights is, I would say, the most important, the main treaty from the Council of Europe. It opened for signature on November 4, 1950, and entered into force on September 3rd, 1953, after 10 ratifications. And the ratification of the European Convention on Human Rights is a prerequisite for membership in the Council of Europe. So any new country that would like to join now first needs to ratify the European Convention on Human Rights. I already mentioned that all EU member states are members of the Council of Europe and have ratified the European Convention on Human Rights. But the EU itself is also on the way of becoming a member of the European Convention on Human Rights. EU accession to the European Convention on Human Rights is actually a legal obligation for the EU, according to Article 6, Paragraph 2 of the Treaty on the European Union. And the negotiations for the EU's accessions began in July 2010. Provisional agreement was reached in 2023. However, they're not a full member yet because the EU still needs to resolve some remaining internal issues, in particular with regard to the jurisdiction of the Court of Justice of the European Union over allegations of fundamental rights violations relating to acts or omissions under the EU's common foreign and security policy. It's also worth mentioning that the European Convention on Human Rights was the first instrument to give effect to certain rights from the Universal Declaration of Human Rights, which itself is non-binding, even though many of the rights contained in it are now part of customary international law. And yeah, they have been included in other treaties, but the European Convention on Human Rights was the first one. Several rights have been added to the European Convention on Human Rights over the years with the adoption of additional protocols. For example, the abolition of the death penalty in all circumstances. That was protocol number 13. All states have signed and ratified it. Azerbaijan signed the protocol in 2023, but has not yet ratified it. Other rights that have been added are, for example, the protection of property, the right to free elections, and freedom of movement. The enforcement of the engagements that are contained in the European Convention on Human Rights can be requested at the European Court of Human Rights, which Elon will talk about in just a little bit. The court calls the European Convention on Human Rights a living instrument, meaning it interprets it dynamically in light of present-day conditions. This approach allows applying the European Convention on Human Rights to situations that were unforeseeable when it was adopted in 1950, including to issues related to new technologies, such as AI, or interpreting the right to a healthy environment. The right to a healthy environment was also discussed by the court in a recent major climate case in 2024, the case of Verein Klimasenioren Schweiz and others versus Switzerland, which I will also talk about more in detail later. So this slide just lists some of the major rights and prohibitions contained in the European Convention on Human Rights and its additional protocols. And I will not talk about all of them now. We will talk about a few selected ones later. For example, Elon will talk more about Article 8, the respect for private and family life. But we just wanted to give you a brief overview at the beginning of this webinar. And I'm also going to put a link to the European Convention on Human Rights in the chat, in case you want to look up the rights. And the slides also have some additional links that you can access later. So for example, here's also, you can see the, right here, prohibits the death penalty, protocols number 6 and 13, which I just mentioned earlier.
Thanks, Jenny. So while the member states and their judiciary still carry the main obligation for ensuring compliance with the European Convention of Human Rights, to ensure the promise of never again, a court was established in 1959. And the court was established together with the Commission on Human Rights under Article 19 of the ECHR. The system meant that the European Commission of Human Rights, a body elected by the Committee of Ministers, aka the foreign minister of each member states of the Council of Europe, had to review the admissibility of cases before they were brought before a panel and also sought to reach friendly settlements. At its creation, and this continues also today, it only had jurisdiction over the ECHR and its protocols. In 1898, the court was reformed through Protocol 11, and an independent full-time court was established. This is the court we know today. Here one may consider the expansion of the Council of Europe during that time and note that in 1998 there were already 39 member states compared to only 15 members in 1959. The wording of Protocol 11 certainly point to the expansion as a reason for the establishment of the court, saying, considering the urgent need to restructure the control machinery established by the Convention in order to maintain and improve the efficiency of its protection of human rights and fundamental freedoms, mainly in view of the increase in the number of applications and the growing membership of the Council of Europe. As a result, the permanent and independent court that we know today was created, with one judge from each member state, hearing cases in groups of 3 judges for committees, 7 judges for chambers, and 17 judges in the Grand Chamber. The Grand Chamber hears cases either at request by one of the parties following a chamber judgment, or if it is relinquished by a chamber. Both situations are exceptional, though. For example, the climate case, Klimasenioren, that Jenny just mentioned earlier, was heard by the Grand Chamber only. Other examples include the Savran versus Denmark case, where the Grand Chamber changed the ruling and invalidated an Article 3 violation and instead found an Article 8 violation, which we shall know as the private and family life protections. The Grand Chamber can thus either affirm or reverse a decision, but it can also hear them straight away. The 1998 reform also created the registry and plenary court. Through Protocol 16, the court now can also, at the request of the member states' judicial bodies, deliver advisory opinions, and I'll talk about that in a little bit. After the establishment of the permanent court, a case could be brought. How a case could be brought was changed, and now it was very interesting because now it offered the individual a unique opportunity to directly petition the court once all domestic remedies, which is typically a multi-step court process, had been exhausted. From the chart, which I borrowed from the Council of Europe's website, you can follow the process of how cases are decided, allowing inadmissible decisions to be made by a single judge, while a 3-judge committee or 7-judge chamber can hear a case and rule on the merits. The chamber can also refer a case directly to the Grand Chamber, as I mentioned before, or the Grand Chamber can hear it on appeal. For advisory opinion, it is the highest national court or tribunal that asks for the advisory opinion, and it is then reviewed by a 5-judge panel made up of judges from the Grand Chamber. Note that unlike the courts of other judgments, these are not binding, these advisory opinions. As I mentioned previously, only the convention and its protocols are subject to jurisdiction of the court, and individual member states have a margin of appreciation at how they fulfill their legal obligations under the convention. So that's called the margin of appreciation doctrine, meaning the room to act with which the member states have in fulfilling the obligations of the convention. And another important doctrine is the idea that, and Jenny mentioned this before, that the ECHR is a living text. And this was expressed in the Tyra versus United Kingdom decision from 1978, specifying that the court must also recall that the convention is a living instrument, which, as the commission rightly stressed, must be interpreted in the light of present-day conditions. In the case now before the court, it also mentioned how other aspects that they were already looking at legislation on the judicial corporal punishment. But the stressing importance of this decision was that it has to be in present of light of present-day conditions. The living text and doctrine is important because while the text and obligations found in the ECHR were made in the 1950s, many of the situations that the court has dealt with since then were not foreseen at the time of the drafting of the convention, including because of technological advancements, for example, DNA. In S and Marper versus the United Kingdom, Article 8, respect for human family life violations, was found when fingerprints and DNA was retained, even though the applicant had ultimately not been convicted of a crime. The use of DNA for criminal investigation was not likely foreseen in 1950. Similarly, like Jenny mentioned before, the Klimas and Unoran case on climate change was also was protected under Article 8, which was likely not anticipated either. And as a result, the convention of being a living document, the rights found in this have expanded. And it also covers other things like an online environment, also not present in 1950. And it has been regarded in Article 8, which is the right to respect for private family life, home and correspondence, subject to lawful and proportional interference by public authorities, is the article that has received perhaps the most discussion or on if it's overly broadly interpreted. Not only with regards to migrant rights, which we will talk about later, but also that climate case that Jenny will a little bit deeper to later. Another article, which is interesting, is Article 2, that has found that there is no right to die, but also conversely, no prohibition from allowing a person to commit assisted suicide, as were discussed in Preddy v. UK and Daniel Carstay versus Hungary. So that's two sides of an issue perhaps not contemplated in 1949. In this context, I might add that the ECHR today enjoys constitutional status in several countries as a constitutional legislative text, including in Austria and Sweden. So it is not only the scope of the rights that have expanded, but it's also the number of cases brought. As you can see from this slide, 837 decisions were rendered between 1959 and 1998 versus 38,573 decisions just last year alone and over 7,000 judgments. While the convention does allow for interstate decisions, they are very rare. Only 23 decisions have been decided so far. The ECHR has published some of the impacts of its decisions on individual states and their legislations. For example, how laws and legislations have changed in response to the court judgments. And I'll mention some of them here now, just to get a breadth of how different the amended laws might be. So, for instance, Austria ended a TV monopoly. Bulgaria created an alternative to military service for conscientious objectors. Denmark had to expand the right to not belong to a trade union. Ireland decriminalized homosexual acts. The Netherlands has amended laws on the detention of patients with mental illnesses. Ukraine amended its libel legislation. And the United Kingdom banned corporal punishment in school, just to name a few. Typically, a majority of these leading judgments are implemented, although the typical time for implementation has risen over the years and is now over 5 years from decision to full implementation, which we will talk about a little bit later.
Thanks, Elin. So let's talk about what happens after the court renders a judgment. Article 46 provides that state parties to the European Convention on Human Rights must abide by the judgments of the court. The execution of the judgments is supervised by the Committee of Ministers. Just for a side note, so the Committee of Ministers are the ministers for foreign affairs of the member states of the Council of Europe. And it's, if you want to look at the statute, Chapter 4 describes the Committee of Ministers. So in order to supervise the execution of the judgments, the Committee of Ministers has adopted the rules of the Committee of Ministers for the supervision of the execution of judgments and of the terms of friendly settlements. It's a very long name. In May of 2006. And those rules were last amended in 2022. And they reflect the principles of state responsibility. It means state parties are generally given leeway in how to execute a judgment, so that they have a margin of appreciation. In 2010, the Committee of Ministers adopted another document on the modalities for a new twin-track supervision system. And the document stated two things. So first, it established the principle of continuous supervision. This means that all final judgments remain under the continuous supervision of the Committee of Ministers until they decide to close the supervision procedure by adopting a final resolution. And then second, it established a twin-track approach for the supervision of cases, meaning cases are divided into standard supervision and enhanced supervision. So in general, all cases pending in the supervision process will be examined under the standard supervision track, unless, because of its specific nature, a case warrants consideration under the enhanced supervision track. So that's the principle of prioritization. The Committee of Ministers meets quarterly and to discuss cases, but because of this twin-track approach, not every case is discussed at those meetings. Okay, so what types of cases are actually subject to the enhanced supervision procedure? Cases subject to enhanced supervision are generally the following. Judgments requiring urgent individual measures. So, for example, an applicant is in detention, needs to be released immediately. Pilot judgments, judgments raising structural and or complex problems as either identified by the court or by the Committee of Ministers. Interstate cases, and also any case upon request of a member state or the Secretariat of the Council of Europe. So how does the supervision of the execution work in practice? Okay, so first, member states must present an action plan or action report as soon as possible or within 6 months at the latest after the judgment becomes final. They submit an action report when they think that all necessary measures have been taken, nothing else needs to be done. An action plan, on the other hand, lays out the measures that the country intends to take to implement the judgment of the court. So if a case is considered under the standard procedure, the Committee of Ministers verifies whether or not a plan or report has been presented. On the other hand, if the case is subject to the enhanced procedure, the Committee of Ministers is more involved and proactive. So, for example, they assist the country in preparing and implementing the action plans. Cases may also be transferred from standard supervision to enhanced supervision and vice versa. For example, when no action plan or report is presented, even after a reminder from the Committee of Ministers. And like I already mentioned, countries have a margin of appreciation to execute the judgment. That means the ultimate choice of the measures to be taken remains with the states. However, the court has also said that the measures must be compatible with the, quote, conclusions and spirit set out in the court's judgment. So this here is a screenshot of the website of the Department for the Execution of Judgments from the Committee of Ministers, where you can find lots of useful information about the execution of judgments. And Elin is going to talk more a little bit about the implementation now.
Thank you, Jenny. So where does one find the implementation status after a verdict against the state? As mentioned earlier by Jenny, the implementation standards can also be found in the annual reports. In addition, organizations such as ENRI, the European Network of National Human Rights Institutions, also promote the implementation of international human rights instrument and monitor the compliance with the ECHR jurisprudence. As you can see from this screenshot, there are actually three countries, namely Andorra, Liechtenstein, and Sweden, that have implemented all their cases, so meaning 100%. One should note that they are not the countries that have the most cases against them either, so there might be a reason for that. But you could also see that Bulgaria and Cyprus, if you look at the total cases, including repetitive cases, which has implemented less than the average of judgments, still have an implementation rate of 81%. The lowest implementation rates are found in Azerbaijan and Russia, but Russia is also one of the countries with the most cases, and as Jenny will be described later, was indeed expelled from the Council of Europe. So that Russia might be a special case. The relatively high implementation rate, after all, can probably be found in that margin of appreciation that we talked about how judges may implement it. But overall, it does typically require new legislation. So it's generally not enough that you only pay the victim compensation, but that you also change the underlying reason for the violation of the right. So, for example, in the case of MA versus Denmark, which was on restrictions on family reunification, Denmark amended a family reunification restriction, which limited family reunification for 3 years, and then it shortened it to only 2 years. And that was accepted as a final resolution. So they just changed it. They just tweaked the law, you could say. It's 3 years versus 2 years on how grave the impact was on the individual person. One should, in this context, also remember that the full implementation, like I mentioned before, is taking much longer now. And it does take an average of 5 years for the implementation to go from court decision to final implementation, final full implementation. And back to Jenny.
Thanks, Elin. Okay, so what happens if a state fails to execute a judgment even after reminders from the Committee of Ministers? So in 2010, the possibility to initiate infringement proceedings against the state in question in exceptional circumstances was added to the European Convention on Human Rights by Protocol number 14. So Article 46, paragraph 4 provides that the Committee of Ministers must serve formal notice on the state party and then refer the matter to the European Court of Human Rights by a majority vote of 2/3. So then, if the court finds a violation, the Committee of Ministers must decide what measures to take. The last resort is to expel the country, which I will talk about in a little bit. If the court finds no violation, then the Committee of Ministers must close the examination. And I'm going to go back to this slide here. So the website for the Department for the Execution of Judgments then has also a database here, the HUDOC exec, where you can look up all the cases, which is very helpful. Also country fact sheets, thematic fact sheets. how the countries implement the judgments. So that's helpful. And Elon already mentioned the annual reports, which can be found here. Okay, so now we talked about the theory. Let's talk about some actual examples. So infringement proceedings have only been initiated twice so far. The first infringement proceedings, this was the case of Ilgar Mammadov versus Azerbaijan, which was decided in 2019. So let's talk about the initial case first. So the applicant Mammadov was a well-known opposition politician and activist. In 2013, he was charged with organizing or actively participating in actions against the public order, and he was placed in pre-trial detention. In the same year, he submitted his application to the European Court of Human Rights. In March of 2014, the Azerbaijani authorities concluded domestic judicial proceedings and sentenced him to 7 years of imprisonment. The European Court of Human Rights found in favor of Mammadov that the reasons for his pretrial detention were unlawful. However, the court only issued a declaratory judgment, which was silent on the appropriate remedies. So then in December 2014, the Committee of Ministers examined the execution of the judgment and called for the release of the applicant. Azerbaijan argued that the court judgment did not call for his release and refused. Because, like I said, it was just a declaratory judgment. The case was under supervision for several years until October 2017, when the Committee of Ministers put Azerbaijan on formal notice that it had failed to fulfill its obligation to comply with the judgment. 2 months later, in December 2017, the Committee of Ministers referred the case to the European Court on Human Rights. Then the next year, in August of 2018, while the infringement case was pending at the court, the applicant was released from prison. So in its decision, the European Court of Human Rights clarified 3 things. So first, because this was the first time an infringement case had been brought, it clarified the general scope of infringement proceedings. It stated that during infringement proceedings, there was no reopening of the question of violation, which was decided in the initial case. And it would also not provide for the payment of financial penalties. So second, the court clarified, because the 2014 initial judgment was a declaratory judgment, it had to clarify what it required in terms of remedies. So it held that even though the judgment did not explicitly call for the release of the applicant, the findings and spirit of the judgment required his release. So that's what I already mentioned before. Countries do have a margin of appreciation, but the measures that they're taking or not taking have to comply with the findings and spirit of the judgment. So that's a limit to their margin of appreciation. Third, the court clarified the time frame to assess compliance, as the applicant was released while the case was pending. It then held that the relevant time frame was the date on which the question under Article 46, paragraph 4 was referred to the court. So that was before the applicant was actually released. So this did not factor into the decision of the court. The second infringement case was the case of Kavala versus Turkey, decided in 2022. And the facts in this case were very similar to the case that I just discussed. In the initial judgment there, the court decided on December 10, 2019, that by holding the applicant Kavala in pretrial detention since November 2017 and prosecuting him on the basis of his human rights activities, the Turkish authorities had, and I quote here, pursued an ulterior purpose, namely to silence him as a human rights defender. The court found a violation of Article 5 and 18, and this time the court explicitly ordered the immediate release of the applicant. And following the initial judgment, the Turkish authorities initiated multiple subsequent criminal proceedings against Kavala, which were based on the same facts, and continued his detention. In May 2020, the initial judgment became final and was submitted to the Committee of Ministers to supervise its execution. The Committee of Ministers classified the case in the enhanced procedure because they said it required urgent individual measures, the immediate release of the applicant, and it disclosed a complex problem, as I said. So then in February 2022, so that's almost 2 years later, the Committee of Ministers referred the case to the European Court of Human Rights for infringement proceedings, after it already adopted 10 decisions and 3 interim resolutions in this matter. Yeah, and the applicant was still being detained. In July of 2022, the European Court of Human Rights ruled that the continued detention violated Article 46. And it's very interesting, and I wanted to mention that there's actually a new case now from the applicant Kavala against Turkey pending at the European Court of Human Rights, which was lodged in January 2021. And a Grand Chamber public hearing in this case is set for next month, actually, March 25th, 2026. So the case here concerns Mr. Kavala's detention after the initial 2019 judgment and the ensuing criminal proceedings in Turkey, which I mentioned, in which he was then sentenced to aggravated life imprisonment. So it's interesting because, and among other things, the court will now have to decide what relevance the initial case and also the subsequent infringement proceedings have with regard to the current case, if they have any influence at all. Like I just said, so there have only been 2 infringement cases so far. But there might possibly a new case, the case I've been mentioning several times already, Verein Klimasenioren Schweiz and others versus Switzerland. So let's briefly talk about the initial case there in case you don't know about it. So in September 2024, the European Court of Human Rights held that Switzerland failed to comply with its positive obligation to implement sufficient measures to combat climate change. And then following this judgment, both houses of the Swiss Parliament stated that even though they respect the court, they respect the rights enshrined in the European Convention on Human Rights, they consider the judgment an act of judicial overreach, judicial activism. They reminded the court of the principles of subsidiarity, that they do have a margin of appreciation, and they stated that the current legislative developments, which were already ongoing while the court decided the case, that they are sufficient to implement the human rights dimensions of the judgment, and then that nothing else needs to be done. So the case is currently in enhanced supervision status because the Committee of Ministers considers it a complex problem. They last examined it during its September 2025 meeting. Switzerland has paid just satisfaction to the applicants. However, the applicants and an NGO coalition, they consider that the Swiss authorities have not complied with the court's judgment, that there's still work to do, that they need to implement the judgment, that the current legislative developments are not enough. And it submitted statements to the Committee of Ministers to that effect. So it remains to be seen what will happen, but it's definitely an interesting case to follow. Okay, so let's briefly talk about when can you expel a country. So Article 8 of the Council of Europe Statute provides any member of the Council of Europe which has seriously violated Article 3 may be suspended from its right of representation and requested by the Committee of Ministers to withdraw under Article 7. If such member does not comply with this request, the committee may decide that it has ceased to be a member of the Council as from such date as the committee may determine. So I already said expelling a country is a last resort. So let's talk about the example of Russia, which was expelled not because it did not implement a few decisions, but due to its war of aggression against Ukraine. So Russia joined the Council of Europe on February 28th, 1996, and was a member for 26 years. But then on February 25, 2022, the Committee of Ministers decided to launch the procedure provided by Article 8 of the statute, which I read to you just a second ago, and agreed to suspend Russia from its right of representation in the Council of Europe. Then on March 10, 2022, the Committee of Ministers decided to consult the Parliamentary Assembly on a potential further use of Article 8 of the statute. And a few days later, on March 15, 2022, the Parliamentary Assembly unanimously adopted an opinion which considered that Russia could no longer be a member. At the same time, though, the Russian government informed the Secretary General of its withdrawal from the Council of Europe in accordance with the statute and of its intention to denounce the European Convention on Human Rights. A day later, on March 16, 2022, Russia was expelled from the Council of Europe, and ceased to be a party to the European Convention on Human Rights on September 16th, 2022. So it's interesting, though, the European Court of Human Rights remains competent to deal with applications against Russia concerning actions or omissions occurring up to that date, so up until September 16th, 2022. And the numbers are very interesting too. In 2022, there were actually 17,450 applications pending against Russia before the court. And the Committee of Ministers continues to supervise the execution of the judgments. But the problem is that the communication has ceased between Russia and the Council of Europe. So it remains to be seen how effective this supervision can actually be. So back to you, Elin.
Thanks, Jenny. That covered what happens when you don't implement the decision. But what about when you seek to implement a decision or when you try to find more information about a decision? What should you do? Well, in October of 2022, the court launched what it's called its knowledge sharing tool with a mission to share convention case law knowledge. The service replaces the monthly compilation of the legal summaries that some of you may be familiar with, and it is updated weekly and allows for cases to be accessed by article or themes, such as migration. While the information contained therein is not binding on the court, it serves as a useful resource for member states and researchers looking for the most current interpretation of the European Court case law, and also links to secondary sources. A note here about implementation legislation looks, again, we talked about this before, it doesn't have to be a complete overhaul of a certain area of law. It may well be in certain cases, but sometimes, like in the MA versus Denmark case, it is enough to just change a restriction from 3 years to 2 years. So it really depends on what the violation is and how grave the violation is to see what you can do with it. And I will, like Jenny did, try to put this in the chat too. This, see, I think it worked.
Thanks, Ela. So as we can see, enforcement of the decision is not always easy. So there have been scholars, NGOs have proposed several changes to improve the enforcement of the rights contained in the European Convention of Human Rights and to improve the enforcement of judgments of the court. So first, it has been proposed to introduce pecuniary sanctions for non-implementation and non-compliance. So for example, by having daily fines. Second, it has been proposed to award jus cogens status to the European Convention on Human Rights. So jus cogens means that it is universally recognized that no derogation is permitted, although that might not actually help enforcement of the decisions just because it has a different status now. Another idea is the practice of naming and shaming, which is a tool which is often used in international law. And that would mean publishing the cases of member states' unreasonable failure to implement a decision. Lastly, educating the public could help. Oftentimes, the public is not aware of decisions that are made by the court, or they're not aware of the rights they have under the European Convention on Human Rights. So that could also be helpful if people know that there has been a decision that influences their rights. If they know about it, then they might advocate more for implementation.
Thanks, Jenny. So clearly, the reach of the European Convention of Human Rights and its importance has undoubtedly grown since 1950. In the recent years, there has been a discussion on how the ECHR is dealing with what some member states have dubbed unforeseen challenges, calling for an amendment or a change to the convention. In particular, some member states argue that the jurisprudence with respect to migration hinders them to take what they deem necessary measures. This resulted in 9 member states, led by Denmark and Italy, to write a letter where they proposed changes to the ECHR in May of last year. And then in December of last year, a joint statement was delivered to the Conference of Ministers of the Council of Europe and it was signed by a slight majority of member states, 27 out of 46. So you can see that Denmark and Italy gained some traction there. The letter particularly noted that our governments have a duty to guarantee the human rights and fundamental freedoms of our peoples, including the right to live in peace, freedom, and security, to preserve the values of our societies, and to effectively protect our borders, prevent illegal border crossings, and counter migration smuggling networks. So that's kind of what they're arguing, but they also reaffirmed that they have a strong belief in the Council of Europe, in the European values, democracy, the rule of law, and human rights. They reaffirmed their commitment to the Convention and support for the work and independence of the European Court of Human Rights, as well as democratic security. However, it also sought to address the following issues: expulsion of foreigners convicted of serious crimes, clarity about the inhumane and degrading treatments, innovative and durable solutions to address migration, decision-making in migration cases, and the instrumentalization of migration, which has been more acute, I guess, in recent years. Now, through its lifetimes, not all of the European Court judgments have been popular, but the current situation where a majority of states have expressed that they wish to reform certain aspects of the ECHR, in particular with regards to migration, is a rather new situation. Some parties in the United Kingdom have even gone so far as to suggest that they would leave the convention outright, or leave and then rejoin with a reservation. While this is a drastic measure, it is not entirely without precedent. Actually, as the Sweden left and rejoined the Council of Europe Convention on the Reduction of Multiple Nationality and on military obligations in the case of multiple nationality, and then rejoined a few days later, or a short while later anyway, in 2002, when it changed its Citizenship Act and allowed for dual multiple citizenship. So then it put in a reservation. So by some, this has been dubbed the Swedish option. However, the European Court of Human Rights is the final arbiter of acceptable reservations. So it has the power to approve the reservation or not. So it's not clear if that would be a successful route to take. And unsurprisingly, there are also been calls for less dramatic changes than leaving. And I'll address some of those suggestions here right now. For instance, one suggestion has been, if these countries, now it would have to be all 46, are in agreement, the CEO member states could create a new protocol similar to the Brighton Declaration, Protocol 15, which was adopted by the Council of Europe and reconfirmed the principle of subsidiarity and the margin of appreciation. Especially the change to the preamble of the convention reads, affirming that the high contracting parties, in accordance with the principle of subsidiarity, have primary responsibility to secure the rights and freedoms defined in this convention and the protocols thereto, and that in doing so they enjoy a margin of appreciation subject to supervisory jurisdiction of the European Court of Human Rights established by the convention. The Protocol 15 also added age limits for judges, and then it entered into force in 2022. Another option could be a jointly issued interpretive declaration by all parties with regards to certain articles of the convention. Something else that has been discussed is to introduce reservations at this time without even leaving. You just introduce a reservation and say, we reserve against this. Or introduce unilateral interpretation declarations. You can do it, but the question is, how successful are you going to be? If there is no agreement, after all, you have to have 46 member states to agree. Some suggest the notion of quiet quitting, meaning you just do what some other member states have done. You stay a party. You pay the victim that brought the case, but you're doing nothing further. You don't change the legislation, and if a similar case comes up in your country, you just go against the decision and treat them as if the judgment didn't happen. Now, this may, of course, cause infringement proceedings, as Jenny described, but perhaps the likelihood that it will result in expulsion, especially if there's a large minority or small majority group of countries that do it in a similar way or on a similar theme, is probably low. One might here remember that Russia's expulsion was based on repeated Article 3 violations, violations of rule of law and human rights, not quote unquote merely failing to implement a few decisions. So as we sum up and perhaps try to answer the question posed by this webinar, is the European Convention an efficient enforcer or a toothless tiger? At the age of 75, there is agreement that the ECHR has been, if nothing else, very impactful and influential. It enjoys constitutional protections in several member states, which ensures an enduring legacy in at least those member states. And despite some recent criticisms of overreach, it continues to enjoy protection and support from most of its members, with perhaps some surgical work to be done in certain areas if agreement can be had. Has it managed to ensure peace in Europe? Sadly, no. We will see how the Council of Ministers proceed with the critique from the 27 member states and what the declaration that is expected in May will contain. In the meantime, for those who wish to follow the developments of the court, the Grain Chamber has a website where it publishes upcoming hearings. For example, there is one next week, and then the one that Jenny mentioned on March 25. I will try to put that link in the chat too, and that will be interesting to follow as well. But we have time come to the conclusion of our presentation. But before we take your questions, we would like to remind you that you can always reach out with questions via Ask the Librarian link that is provided here on this slide. If we don't get to your question today, or if you have a question that is very detailed and requires more research. Our next webinar is on March 26th on the role of legislative bodies in the Arab League member states, a comparative overview. We hope you can join our colleague, George Sadek, then. And then I will try to look at your questions. Let's see. So the first question we had was, you mentioned that the ECHR has constitutional law studies in some member state. Could you tell us more about it? Well, so for instance, that means I'll take one of my jurisdictions as an example, and I know Jenny can speak to Austria. So Sweden has 4 legislative texts, constitutional legislative text, which can only be amended first through a decision in the parliament, and then you have to, with a certain majority threshold, and then you have to have a national election and again a vote and a certain majority again before you can change it. So it's a much more difficult process of changing it. And so in one of those 4 texts, it refers specifically to the European Convention of Human Rights and provides that no law can be adopted that violates Sweden's obligations because of the European Convention of Human Rights. So in that sense, that also means not only can you not adopt any law, you also have to interpret the current laws in a way that is compliant with ECHR and its case law. I don't know, Jenny, if you want to speak to Austria on that point.
Sure, because we already mentioned Austria. So Austria, for example, does not have a single constitutional document. So not like the US Constitution here. So instead, Austria has several laws that have constitutional law status. Their main or like core constitutional statute is the Federal Constitutional Act, but that does not contain a comprehensive list of fundamental or human rights. So that means after Austria joined the Council of Europe, it accorded the European Convention on Human Rights and its additional protocols constitutional law status, and that was in 1964. So individuals can then challenge infringements of constitutionally guaranteed rights contained in the European Convention on Human Rights directly before the Constitutional Court. So it's very interesting. So the court then, will just talk about the European Convention on Human Rights. There was actually just recently, for example, a case at the Constitutional Court where they legalized social egg freezing. And there was where they found there the ban that Austria had was a violation of the right to respect for private and family life, protected by Article 8 of the European Convention on Human Rights. So in Austria you can go directly and say my rights from the European Convention on Human Rights are infringed.
Thanks, Jenny. I have another question here that says, you mentioned advisory opinions of the European Courts of Human Rights. How common are they and how many have been issued? So for last year, by in September 2025, there had been 12 requests and 7 had been answered. And this is it's part of the grain chamber that hears it. So it is becoming more, I think, it's a roughly recent procedure that certain states are taking advantage of. But you can also see that those are not binding. So we'll see how that influences whether or not people want to use them or not. But there is, if you want, I could put that in the chat too. We'll put this one. Yeah, but some information on it. There we go.
Let's see, we have a few more questions here in the chat. I think, Elon, I can maybe take this question about Turkey because I talked about that.
Yes, excellent.
So it says here, Turkey seemed to have repeatedly failed to comply with judgments of the European Court of Human Rights. What measures has the Council of Ministers taken, or the Council of Europe taken against Turkey to bring it into compliance with its treaty obligations? So that's a very good question. As we can see from the second case that's now pending at the European Court of Human Rights, there's not so much they can actually do besides adopting decisions. And like I said, for the first case, the Committee of Ministers adopted 10 decisions, 3 interim resolutions in the matter. Then they had the infringement proceedings. Now there's the second case pending. So to be honest, they can't do much, and that's also why they're calling for reform. They're saying, well, we have to somehow. Normally, you say, well, the states will comply with their treaty obligations. That's what they do, and this is with a lot of international law obligations. You kind of have to hope that the states will comply with their obligations, but it's hard to force a sovereign state to do anything, and that's why I said, for example, we need something that hurts, like daily fines if you don't comply with the judgments of the court. But yeah, so it's difficult. There's not much else they can do besides publicizing it and calling on Turkey to do it. So yeah, unfortunately, there's nothing else they can do right now, and we'll see what the second case now does. And Elon mentioned at the beginning also that there's actually a lot of cases against Turkey pending, that they have a good amount of cases, unlike others that also comply with all the judgment. Like Andorra, I think, has 8 judgments against it, and that's why it's also easier to have a 100% implementation rate than other countries that have thousands of cases against them. Let's see, Elon, do you want to take another question, or?
I wondered if you wanted to speak about the EU accession.
Yeah, okay, I see this question.
So the question is, could you speak more to what the legal and political complexities are in the EU accession to the European Convention?
Yeah, that's a good question. Thank you so much. Yeah, it is, as you can see, even though it is an obligation for the EU to join the European Convention of Human Rights, it's a long process. And currently, the European Commission has requested an opinion of from the Court of Justice of the European Union in November 2025 on the revised agreement for EU accession to the European Convention on Human Rights. So they're waiting for the court to issue its opinion. So that's going to take a while. It's really with regard to the jurisdiction of the court. That's the main issue with regard to the common foreign and security policy. And obviously, because once the EU accedes, as we heard, the European Court of Human Rights then is the enforcer of the obligations under the European Convention on Human Rights. So the Court of Justice of the European Union wouldn't have anything to say in those matters anymore, which obviously no court wants to do that, wants to have that. So they're waiting on the opinion. And then also following that, once the opinion is issued, then all member states of the European Union will have to ratify this again, because it's a change to the treaties. So that has to go through the national processes. So that's also complicated. Every time EU treaties are changed, that takes a while because every country has a different procedure. Sometimes there might also be a referendum in a certain state. So it really depends. So it will still take a while, even after we have the opinion from the Court of Justice of the European Union.
Thanks, Jenny. I have a question here. And it's first it's a statement and then it's a question, but happy to see that the death penalty abolished, but does the right to life conflict with Europe's abortion laws? And that's it's an interesting question. As I mentioned during the presentation, euthanasia has been an issue before the court. What's interesting with the question with abortion is the European Convention of Human Rights does not decide when life begins. So it has in court, in case law, it has been determined that determining when life, or thus the protection for life, begins is within the margin of appreciation for each member states. So Article 2 does not provide a hindrance for abortion. And in fact, many cases on abortion are instead found under Article 8, which would be the right to private and family life, and that there is a right to abortion in certain cases. For instance, decision against Poland. So I'm going to put just a quick guide for that into the chat if somebody's interested on the content of Article 2.
Thanks, Elin. I would also, I guess, add that, the court has also not said that Article 2, the right to life, they have not extended that to a fetus. So, yes.
Right.
So
it has not defined when life begins. So I guess technically a country could, if they implemented a decision like in, saying that a fetus has right to life, that would be a different scenario.
Yeah, but the court, especially with regard to abortion, they always, in a lot of cases, they could look to, is there like a general consensus among the member states? And they, especially with regard to abortion, they say there's a, the margin of appreciation is even, I guess, wider than usual, let's say. There's different, approaches. And so they focus also more on access to procedures if they're already legal, for example.
Exactly. Thank you, Jenny. I think that we'll have to conclude. I don't think we have time to take any more questions. So there are
I guess we can maybe take this one quick one.
Okay, go ahead.
Yeah, there's one on how is the public informed at present and what improvements have been done in keeping the public informed. Yes, that's just normally up to the member states how they do it. So this is, the court has press releases, but how the individual member states inform the public, that's, up to them. So I guess there's a certain, gap. But the court, normally is pretty good with all the press releases.
I did see some discussion in the UK that they want it to become more part of a proponents for human rights want to include it better in like the civic education in schools, that so that students early on learn, that the European Convention exists and certain things, but that's more on a national basis rather than from the European Convention of or the Council of Europe.
Exactly. Yeah. Well, it looks like
We're at
have run out
time.
of time. Yeah.
Sorry, guys.
But
But
I
like
mean,
again, yeah, the Ask a Librarian is right there, link. So whatever you had a question, please send it and we will look at it. We thank you so much for coming today, and spending this time with us.
thank you so much.